we're gonna look at 342, which we had a bunch of testimony yesterday. Here's the game plan. This is going to be sent over to Commerce because most of the decisions be made are for Commerce. My intention is to go over with everybody here to make sure I captured all of our concerns. I'm due to testify right after the floor, which will probably be late for a few minutes just to go over what the concerns are. And also included in the concerns is that there are some additional covered individuals that we would like to see added. So that's one part. And then I'm going to just ask folks if they're okay that I've properly covered the concerns. The next thing I'm going to do is just to ask people if the underlying need for this that we heard from witnesses, as far as I guess along the lines, do we agree that we should make it more difficult to obtain personal identifying information from the internet that this bill purports to do? So I will be asking that as well after I go over the concerns, and then looking specifically to make sure that we are fine as a Judiciary Committee with the relief that's on page 7. So anyway, if you all have your things, I'm going to walk through and make sure I haven't missed anything. So on page 4, line 10 and 11, there's concern about the concept of within a searchable list or database, that it's like searchable by whom, if there's an internal database, that this shouldn't be covered. Is that my understanding from that was something you raised, Zach?
Well, so my thinking on this is, right, it's the component of whether it's a publicly searchable list,
right,
or if it's not.
Yeah. Public.
Yeah, exactly.
Yeah. So that was the first one.
Because everyone has internal databases that they search.
Right. Yeah, no, absolutely. I agree. And so I'm going to raise that and as well. So I already went through these concerns briefly with the sponsor of the bill, and she recognized that was an issue. She recognized the 10 days, which I'll get to as an issue, but I'm going to present it to the whole committee as well.
Yeah.
So the next thing I have on the same page is actually the language that Judge Zone suggested, and I'm going to suggest it to them. And if they need to hear from zoning, which I don't think they will, he said to essentially on line 20 to strike of the and insert in a state court located in Vermont, and then striking on line 21, Supreme Court, Superior Court, or Vermont Judicial Bureau. That was my understanding of his suggestion. The additional covered people that have been suggested, there's victim advocates, including the ones in the state's attorney's office and the ones in state police. And there's the mental health crisis workers who are embedded with the state police. It is courts
covered under the social workers. Not that it can't be added here too.
Yeah. I don't.
I thought they were.
That was a request from one of the witnesses.
I'm not going to suggest to remove it, but
yeah,
it just seems like they would already be covered.
But belt and suspenders, I guess.
Yeah.
Court staff, and the state's attorney's staff, and they're already adding the attorney general. My understanding that they went directly to that. And also on line 12, making it clear that we're talking about U.S. Attorney, Assistant U.S. Attorney for the District of Vermont. The one other thing, I got an email from Big Hartman asking that Human Rights Commission employees, because they are getting a lot of threats due to their position. I don't see any problem with making that recommendation as well.
We should just outlaw databases. Then everybody's covered.
No, for that.
Well, we're heading there.
All right, so the next concern was on.
Before you move on from individuals,
You can agree with me?
yeah, let's outlaw all databases. And I don't use any databases. What do you mean? You were saying that everybody uses databases. Maybe I don't. The royal we. The royal we. Maybe not you. Yeah, but me. AG's office.
Yeah, I checked.
Oh, I didn't hear you. And then the other thing was, what about contractors? So we heard a lot about
Defender General doesn't even want to be in there, but we're gonna leave him in there.
Yeah, but we heard all about all the different people that they contract with, and I don't know if the state's attorney does any contracting.
I don't think so.
Never heard of that. Say that again,
No,
please.
no, we'll leave it, because this is their request and they didn't ask for contractors, so.
Okay, great.
If they wanted a contractor, we'll put that.
They should ask, great.
My next one is, on line 16. The home telephone number, they need to check if that's really what the language should be, because there's, as Kenny suggested, nobody has home telephone numbers anymore. I do, but
I do.
but they need to make it clear that we're talking cell phone numbers and.
Well, they did define it. On page 4.
Oh, okay.
Home telephone number means any
Line
telephone number.
16 to 18.
Oh, okay. Yeah, but.
But it
there's
is curious.
They should still
Yeah.
look at the terminology.
Yeah,
It should probably just be personal telephone.
yes. I think that would be much better.
Who they is
It's
that?
just police person.
Comments, okay, yeah. Comments. All right, the next thing I have is the 10 days issue, which they already have, pro and con data brokers who are gonna address that already, because they knew that was.
I'm sure they do.
Yeah, I knew that was very much an issue, but I suggested, and I'm gonna raise with them that, the concept of, could it be a reasonable time frame? Because that came up and it's tied to the negligence standard, so, all right, so.
And as far as, I mean, my opinion on the 10 days, I certainly want to expand it. And, to get rid of a lot of the, number one, to get rid of a lot of the lawsuits that are really unnecessary if the timeline is extended. And not just the lawsuits, but the court cases. We don't need to add to a backlog.
Yeah, already. So I won't just say, look at that question, we have an issue, that I think from reading at least a lot of the room that we are doubtful that 10 business days is appropriate time. That seems short. That seems short to us.
Well, I thought the recommendation that you made, Chair, on 10 per, and again, like I have my
That
feelings on the bill.
either, but.
But I think that's a step in the right direction, is looking at it per data, per line of data that is disclosed online. 10 per. Can you
I'll just throw I'll throw the two ideas that
But it
came
can't be
out.
10 per data set. But also, can you couch that language a little bit, because we don't know anything about this.
Right, well, that's why they need, because it relates to the function of data brokers, and they got a bunch of people set up to hear about it. But it seems short to us, and I kind of think it to be reasonable,
We did
and
hear testimony that it was perfectly doable.
yes. And this is
Someone
why,
who knows
this is
more
why the
than-
committee, because we'd have to hear from about a dozen people that are not within our jurisdiction to sort that one out.
Again, 10 days is probably totally doable, but it's not happening because there's people being sued because they're not being removed within the 10 days.
Yeah.
So.
Right.
But it might be just a general reluctance that they're not going to.
Yeah.
Period.
It's
So
not
that's
related to
kind
the
of,
language
again,
time.
They're saying, no, I'm not removing them, go to hell. It's not because I can't do it in 10 days. That's kind of the perspective I kind of got.
Okay.
But that was the perspective, but there are instances where they're not able to do it. I mean, if you have a data set that is, 20,000 individuals, I mean, there's just no way that you're able to go through.
I
In
don't
10
know
days,
that.
to remove 20,000.
I don't know that.
I fundamentally,
We're not gonna have 20,000.
Yeah, well, but the thing is that I don't know. I mean.
We don't know. No, but
We
here's
don't
the thing, too, is because this applies to individuals in household, and it's not just the individual covered person, which is why I was asking the question yesterday, is that if you have, say, 2,000 covered individuals, and they each have an average household of 4 people, we're getting up into multiple digits.
Yeah.
Very quickly.
So the 10 days, put 2 flags beside it for.
And this is what I love, is
Commerce
like we're
committee.
saying that Commerce isn't gonna look at that issue.
Yeah, I already.
Of course they're gonna
expressed
look.
That's our biggest issue, and I will again, I have a
Right.
star, there's a star right there.
No, then I knew that.
2 stars, I would put 2 stars,
2
2
stars.
stars right there on that one, biggest concern. All right.
What about sorry,
No, what?
I was gonna say about the $1,000, but maybe you're getting.
Well, so yeah, so my next ones were actually, the one more concern, and I'll back up to the relief, is it shall not be a defensive liability language, and really, questioned that. We questioned that one, but there may be a rationale for that. I will probably spend more time on that one, saying, why the hell is that? It seems like if the names are readily available, that should be a defense.
Right.
So, but we'll see what they do with that. All right, the relief. So going from the bottom to the top, the equitable relief, that's very standard. Reasonable attorney's fees and litigation costs in this kind of litigation is pretty standard. Punitive damages, we don't have to have that in there, but I don't think there's a reason to eliminate it.
Yeah,
I mean, it's, the court could do punitive damage whether we say it or not.
yeah. That's so. And that's kind of why I'm like, why are we saying it?
Well, now the thing is that if we strike it, does that mean that we're saying, are we saying no?
Is that how it works with like legislative?
No, I've heard that argument.
So the judges go and look at what happened in committee and they're like, oh, they struck
No,
Bill.
the judges don't.
Yeah.
Those keen-eyed attorneys.
I see. They say, well,
So you can't be punitive damage. Look
Chair
at the
Malone
legislative
struck.
history. They struck that punitive damage. Obviously, they don't want punitive damage.
but then on the other end, if we add it, are we saying that there should be?
No.
Okay.
I don't think that. I mean, it's like willful or reckless disregard of law. I suppose that's would go after those companies that are, I'm not gonna do this.
Yeah.
Which, I mean, that's a very realistic outcome.
Yeah, so,
Yeah. So that gets, okay, whatever.
so, all right, so the $1,000 per, I mean, I heard that it's not nearly enough. And I'm hearing that if it's a whole bunch of people, it's a lot.
Well, my concern is like if it's a single, if God forbid, a single person has data exposed, it's $1,000. That seems like a pretty
I
reasonable.
don't think it's data exposed. I think it's they decline.
The data
to-
decline. So it's the daily penalty. But what I'm saying is like there is a compounding factor of that it's per line of data of per line of exposed data for covered persons in perpetuity. Like there's no ceiling here
So no, I don't think
for days that is exposed.
it's not by day. It's not,
It's just
there's a
one.
single violation. You did not, I mean, if you keep on disclosing it, you're right.
That's what I'm
Right,
saying. If
keep
you
on
have,
disclosing.
again, if you have a data set of 10,000 and if it is disclosed for days 11, 12, 13, 14, 15, so on and so forth,
Disclosing.
that I'm saying like in the mind of a Google or an Amazon or Microsoft, they don't care. They really don't. And so like the thing is they will keep exposing the data in perpetuity and it just keeps going.
Is the violation the disclosure of the data or the not
The
removal?
non-removal.
So then I would say that it would only be once. So if they're not removing the data, like disclosing it over and over again is not the violation, it's the non-removal based on the.
But it's per entry.
A re-disclosure though would be a violation.
Is, well, that's what I'm asking, is the disclosure the violation?
Redisclosure is covered.
It's, oh, okay.
It's just.
You're right here,
Yeah.
line 14, page 6, the redisclosure of the data.
So does that mean to a different buyer or like, I don't know what that means.
It's very nuanced. I mean, it's very.
So I can explain that we have a concern with that. Essentially, if it's like a one time for each individual as opposed to for like each day or each disclosure, then that's fine. But if you're talking about, like you say, there's 1,000 of these and it's every single day they are just disclosing it, that adds up, that we're not okay with that.
Well, or there's a redisclosure, or like, what if it's also in like, this is kind of what I was getting to with the Cypre Google lawsuit, which happened, I think this was in the early 2020s, is they augment data cells with different pieces of the data. So say my entry was disclosed through, I'm just saying, for example, Redfin or like a mortgage data provider, and it was disclosed in a different place, but it was different data. That's two different disclosures.
Right.
Like it's a very nuanced subject.
So I think this once again gets to
Right.
how the data brokers are
It's just
are working. So I mean, is this the kind of thing where they're disclosing on a daily basis, or is it in response? Presumably, a company that's acting rationally, if they want to have that lawsuit and they don't agree with this, they go ahead and let it disclose once and now they have a lawsuit against them. And then they probably are smart to just hold that back until they've resolved the lawsuit. You know what I mean? It's like, why expose ourselves?
Assuming rational actors.
Right, assuming rational actors, but that again is, I wanted, is like data brokers. I can raise this again
Yeah.
and to the level of nuance that you were just talking about as well. Because I could see that would be problematic if, depending on how these guys actually operate.
Yeah, and again, like I want to assume the best of people and of corporations, but like there's also the realistic world that we live in. If there's some kind of financial benefit to them exposing this data and having it publicly available.
Right, they'll have to do a project.
Which brings us to the most
analysis.
important part of all of this, which is the criminal component.
So
That's what you're getting to.
So there isn't a criminal component in
Not
here.
yet, but it was suggested yesterday. that
It
they wanted.
was, and I suggested to the sponsor of the bill that if they have a desire to get this out before crossover, which apparently they do, if they be adding the criminal thing, we need to get it back. And they can kiss off that. They should probably deal with that at a later date, if at all. That's what I suggested.
But you don't foresee this happening in an amendment.
If it's an amendment, we'll have to come in here as well.
Yeah.
If there's a criminal charge associated with it, that is definitely in our jurisdiction.
Yeah.
We don't, the civil fines, we'll weigh in sometime, but there's lots of stuff that happens in this building that leads to civil fines that never drops here. But once it crosses into criminal stuff, it's gotta come through
Yeah.
here.
So I think then what I would feel comfortable with a flag on the criminal would be just, hey, we heard some testimony that said that the criminal element here is important for enforcement because some of these companies are so big that they don't really care at all about the fine. So we understand you want to get this out before crossover. Just understand that we heard that you're, taking part of Daniel's law, but not all of it may impact how it's implemented. Just make sure you're aware of that.
Right, and I'll make, clear that if that happens, it's gonna have to come back to the sheriff. So, so one last thing I mentioned, I forgot to mention, and I did raise this and I will raise it again today. But I raised it with the sponsor, was the concept of coming up with metrics or some way to evaluate how this is working. And they've done this before in privacy bills, so they are going to have some sort of language to essentially, do some sort of metrics with some sort of some sort of report, just to see how, whether this is working or not. This is to Tom's concern that you raised yesterday. So that's all I have. Have I covered all the concerns? I think I was taking notes as we were talking about it yesterday. And
Can I just break?
Yeah.
I have one other question, and it goes back to the cease disclosing and re-disclosure and everything. I still wonder why we're not saying delete.
Yeah, okay. I did. I'm sorry. I skipped that one. I have that right here. I will just mention that came up as well. All right. So are we good with the concerns? I've covered everything.
Good with concerns.
Okay. So I guess the next question, I just want to see where we are, is if we agree that we should make it more difficult, which is important to do, to obtain personal identifying information from the internet. In other words, do we agree essentially with everybody, general, saying that this would help minimizing access, if in fact this is if it works? Where are we with that?
Yes.
Yeah, you're good with that?
And the piece you had on there, as far as, that you put in there for me to see if it's working or not, I've given that some thought. It's really gonna be impossible to tell if it's working or not, because if somebody does have the idea, they may want to hurt somebody and they go online and can't find their information, we're not gonna know.
Yeah, but there's some sort of metrics to see. I mean, they got to come up with something, even if it is, I think we need to push them to charge somebody with keeping track of what the hell.
No, I don't.
Setting up.
Right, no, and I don't have a problem
We may be
with doing
right that
it,
we
but
can't figure out, we can't prove a negative as a couple people said.
Yeah.
Yeah, and that's understood, I think. But I think, I'm trying to remember whenever we have a bill to put something in to kind of track whether,
Yeah.
whether it's actually doing something.
I would even push it a little further and say not only track whether this is successful, but also just generally speaking, have a unified place where all of this sort of like threatening behavior and information is being collected and considered, right?
Because Office of Information Privacy.
Yeah. Feel free to.
Well, I don't want to create a new office, but like, it sounds like it's the buildings and and
BGS.
BGS, but like, I don't know if they're actually collecting all of that information. I feel like if you want to make sure we're seeing trends and we're making sure that we're able to react to things that are happening, that data is, because I think we kind of heard that from the New Jersey testimony.
Yeah, I'll include that as what I thought about that. So are we good?
Yeah, I would
Are we
say,
good with the general need to try to limit? You're not, but I'm seeing. heads
And
shaking.
not only so I just want to go on the record and say that I'm not opposed to protecting the confidential information of people that are doing such important work on behalf of the state. That's not what I'm against.
Okay,
What I'm against is the environment that this creates and the opportunity for bad actors to come in and take advantage of law enforcement, of covered persons. We have seen happen in New Jersey and is ripe for abuse. And not to mention the people that are behind a lot of, the Atlas data privacy, for example. I mean, you have Harvey Weinstein's lawyers who are backing this. You have venture capital firms from Palo Alto who are multi-billion-dollar corporations who are profit maximizing machines who I did business with in my past life. The only reason they invest in a company is because they want to make money off of it.
right.
So my thinking is, if I'm seeing Lightspeed and Y Combinator come up in the investor report for Data Atlas, and they're the ones sponsoring all this, in what was a very well organized, rollout of testimony, red flags are going off everywhere. And not to mention that David Boies is one of the largest, most prestigious law firms in New York, and his attorneys are being staffed on all these cases in New Jersey. So I just think it creates an environment that is ripe for abuse, and I frankly don't want that to happen in the state of Vermont.
Okay,
So there's my concern.
We'll share that concern. You obviously can share it with the members there as well, but I will mention that.
Yeah.
That was the
10-day thing address a lot of that?
I think that's part of it.
Part of it, yeah.
No, I think it's part of it, but I understand where Zach is coming from as well.
Well, I think if you have to front run your own testimony by saying that you don't want to be viewed as an ambulance chaser, there's probably something pretty like, right? Like if you have to say, well, I'm a very trustworthy individual, but all of a sudden you lay out all this testimony, it kind of calls into question what was actually trustworthy and what was not.
Okay. All right, fair enough. And actually, I'm sure it's going to be here soon. Okay.
I also just want to say that I think both that, I understand that concern, and what this bill is trying to start to get at is also such a big, like
It's huge.
multi-billion-dollar industry. And
Yep.
so, yeah, it's like, it's going to take money to fight money. And
Yeah, I mean, I in my last life, I worked for one of the largest data providers in the world. And so I totally get why data is valuable and how you monetize it,
Mhm.
which is exactly why I'm concerned about this legislation.
Okay.
Good luck, commerce.
All right, so we're gonna move on. I'm gonna be relieving us of the setting accomplice this afternoon.
Say Marty's never been so happy to relieve us of the bill.
You know, I guess probably.
No, I agree.
But it's all set, Rick. It's gonna be. Yep, I appreciate you swinging.
I don't even need to say anything about it.
Nice.
Well, I agree with you. I agree with you, but I don't like to go a lot of what Zach said. But again, we're doing, the one thing I just really want to put out there is all people should be protected, and they are with laws. And we're going a step above and making. Listen, on judicial nominating board, I've never had a lawyer or anybody come up to me and worried about their future, about becoming a lawyer or their family. It's never been brought up to me. So I have a lot of, I think this is way above the state of Vermont to be dealing with. This is more of a federal, the federal board, the federal people, they're not. So I pass it on to them, but again, I don't have a problem with what the intent is. I have a problem with how it would be enforced.
Okay, fair enough. Yep, got it.
Just pass it on to Marcotte and let them have fun.
Okay. All right, we're gonna turn to H222, and thank you for being here. How was it downstairs this morning? Did you have
It
fun?
was great.
All right, excellent. Are we gonna get more bills?
I think you are. They worked on S87 relating to extradition procedures.
Okay, right.
And I wrote an amendment
It's
and
part of the omnibus bill, as I understand.
yep. And so I expect they'll be voting that out probably tomorrow.
Excellent, thank you.
Sure. So for the record, Michelle Childs, Office of Legislative Counsel, and we're looking at the latest draft, 2.1 of an amendment to H222. So it's been a little while since we talked about it because I think it was before break.
Yep.
So just a little recap is that you had a few different DV bills and you're kind of pulling some pieces off the one around the GPS tracking and stalking bill, as well as the language around being able to order someone as part of an RFA to attend domestic violence accountability programming. And so looking at the language on page 1, section 1, so this is in amending the civil protection order language for the definitions for as it applies to orders against stalking and sexual assault. So the only changes to the section from the last version that you saw where it's just a little bit of restructuring. But I think you guys were fairly settled on that one. So there's nothing really substantive that has changed in that section. Page 3, section 2. Now we're moving on to Title 15. So we're in the civil protection orders for family and household members. And section 2 is amending section 1103, which are the final orders. I always just want to point out is because to me, just it seems as though that you should have like first the temporary order and then the final order, but these predate when I joined here. So it was like first you have the final order, then you have the temporary order in the statute. So when we're looking at section 2, we're talking about the final order. And there's just like some kind of cleanup language. And then the substantive stuff is on page 6. So with regard to the final order, if you look at the lead-in language, actually starts on page 4, subdivision 2 on line 10. So the court may include the following. So if they find that there's been abuse and that there is a danger of future abuse, they can order, and there's a long list of things they can order. And you'll see the new language starting on line 7 on page 6. Subdivision I is an order awarding possession of a vehicle to the plaintiff for a set period of time, provided that the plaintiff, and then you have either the joint.
Michelle, can you give us a hypothetical where a vehicle would be awarded?
I would say that's probably better for the witnesses and who are advocating for kind of addition to this. I could in a situation, but I mean, my suggestion would be, let's say if you have someone is a plaintiff and there's a couple of cars in the family that are used, there's children in the family, plaintiff uses one of the vehicles to be taking the kids to daycare, getting to work, doing those types of things, that the court could order as part of that the plaintiff for a certain period of time is able to have possession of the vehicle to do those things. Because if you look at the list of things that the court is allowed to order currently, things like the residence. So, where somebody's going to live, they can order a temporary award of child support. They can do a temporary award of parental rights and responsibilities, things like that.
Thank you.
So I think it's just, things around the idea of kind of just stabilizing the family. So, but the witnesses can probably give you some others, kind of more specific examples. And then starting on line 13, subdivision J is the order, and this is new, so I don't think that the committee has seen this language, but we were getting input over the break from Judge Zone, and then also talking to some of the other stakeholders and witnesses. And this language was recommended by the court. Is that J would be an order requiring the defendant to complete a domestic violence accountability program that is approved by the Council on Domestic Violence at no cost to the defendant. Failure to complete the program shall not be considered a crime for any purpose, including 13 VSA 1030, but may subject the defendant to civil contempt proceedings. So you recall that if you violate a civil protection order, whether you're talking about the Title 15 orders or the Title 12 orders, or the ones with regard to like a protection of a vulnerable adult, violation of that order is a misdemeanor under 13 VSA 1030. And so this is specifically saying that with regard to this particular condition of the RFA, that if the person didn't complete the programming or wasn't in attendance as well, that it would not then qualify them for prosecution under 1030, but they could be found to be in civil contempt. And then additionally, that when usually these final orders are for a year, a period of a year, sometimes plaintiffs will seek to renew those and extend those beyond a year, sometimes not. Is that if the defendant has been ordered as part of the initial RFA to attend these accountability programs and then doesn't complete them, then that can be considered by the court and whether or not to extend the order past the initial time period.
It also can be if they do successfully complete it, it would also be a ground to modify it.
Sure. Yep. Okay, next section is page 7, section 3, and here we're still in the domestic relations title, so still family and household members. This is the temporary order. So you have a similar kind of structure for, if abuse has been found and there's danger of future abuse, the court can make certain orders. But it's a little different because we're talking about an ex parte hearing. It's a temporary order that is usually only in place for 10 days. And so there is an additional additional burden for the court to be able to kind of award possession of the vehicle. So you see is that on subdivision 4 on page 9 is that upon a finding that the plaintiff's possession of a vehicle is necessary to escape abuse or prevent further abuse, the court may award possession of the vehicle to the plaintiff for a set period of time. So, so there's a little higher standard there for the temporary ex parte hearing, as opposed to on the final hearing where the defendant can appear and present evidence. And that follows the model that you have currently in the law for awarding the residence to the plaintiff.
Okay. Questions on the language before we look from a couple of witnesses? Yeah, go ahead, Ian.
Just one on the vehicle language, I guess in both the temporary and the final. I was just looking at it and wondering, the or at the end of subsection C on 4. So does that satisfy a question as to one of these would be sufficient? So
where are you looking to?
On either page 9, line 10, or page wherever the other one is.
Line 10, okay, yeah.
Some of these make a lot of sense that they would be sufficient as a singular. A couple of them, I think, like being the primary payer on a vehicle loan, you could see sort of like an argument that is that sufficient. But with the or language, we're saying any one of these is
any one of those, and purely policy decision for you about how what you want the proof to be. And I totally get lists.
Yeah.
Oh my gosh, they're so confounding. And or conjunctions, we do CLEs in amongst the lawyers to kind of like on how to do lists and how to use conjunctions properly, and when and sometimes means or and such like that. But in this instance, the way that it's structured, it could be any one of those 4.
Yeah. And I'm fine with that. I just wanted to make sure that it was clear enough that we
Mhm.
wouldn't get in a situation where if someone was only satisfying one, that wouldn't be sufficient. But if we feel like ors makes it clear enough.
I also just note, that I did retitle the bill at the end. So, because it was originally or is as introduced relating specifically just to the Domestic Violence Accountability Program, and you expand that to include some of the language from the other bill as well. So I retitled to be an act relating to civil orders of protection.
Questions on the language? Not seen any. Who do I have that's supposed to go first here? I guess Carol. Thanks for being here.
Of course, thank you for having me. Charlie Glisserman, Policy Chair, Policy Director at the Vermont Network Against Domestic and Sexual Violence. I really appreciate the committee taking time on this issue and the opportunity to speak with the committee again. So since the last hearing on this bill, we've spoken with a number of stakeholders about the updated language. We are comfortable with the latest draft and hope the committee will consider advancing it this week. The bill includes multiple important provisions for survivors of violence and will improve their ability to get the relief they need through the civil protection order process. I'd be happy to answer any questions or speak to any components of the bill if that would be helpful.
What do you think about moving it to just being a civil contempt proceeding for violation of the domestic violence program?
So we are fine with this language and think it's unlikely to impact a defendant's engagement with DVAP programming. And it's something that if this bill is implemented, the Domestic Violence Council will monitor data on DVAP completion rates through these referrals. And if for some reason it appears the language is negatively impacting DVAP participation, it's something that we can follow up on with the committee and with other stakeholders.
Would you rather it be just a criminal violation?
I think that the language as it's written right now is appropriate.
Ethan was asking for me, I think.
I know you can ask earlier.
I appreciate it. I was somewhat opposed.
And, you know,
I'm glad to hear.
it is something that we will definitely want to watch.
Okay, other questions for Chuck? That was straightforward. Thank you very much.
Thank you.
We'll hear from Carolyn next.
Good morning. Thank you for having me. I didn't get a chance to be here with you all when you first were taking this bill up, and I'm sorry about that. I was traveling. Well, I'm not sorry about it. I was traveling with my family in Spain on school vacation. So I missed the opportunity to talk with you all at the very beginning about this bill. But I just want to tell you, I think it was super smart to combine all of this domestic violence stuff. Maybe I should be thanking Michelle for that, but combining it into one bill is super smart. And I'm going to basically focus on the accountability programming. And that recommendation came to you from the Domestic Violence Fatality Review Commission. It's the 5th recommendation in our report. I can also tell you that when I met with my boss, Attorney General Clark, it was the first thing that jumped out to her. And she was like, this is great. We really support you moving this bill forward to allow that as an option in RFA hearings. All that being said, I am going to go where Charlie didn't want to go, because I know the network generally doesn't want to see additional criminal liability for anybody. But I would say to you that I think that I support this bill the way it is. If that's language needs to be there to be passed, then it'll all be fine. But if I were to make a suggestion to you, that subsection J, I would simply say an order requiring the defendant to complete a domestic violence accountability program approved by the Council on Domestic Violence. and stop it there. That's personally what I would recommend to you all. But if you think all those other things are important, then include them, because the most important thing is that it's an option in the hearings. And the reason why I think this is so important, I really want to echo what Laura Beerley said to you all. I watched the testimony from last week, and I've never wanted to stand up and applaud before, but Laura's testimony was so good and so authentic about why this is so important. We talk about early intervention all the time, and we sometimes can't figure out how to make that work. It's just such an important option to be able to try to give people the tools they need to modify their behavior. When you think about a relief from abuse order, exactly as Judge Zone said to you, a lot of it's prohibitions. Don't do this, don't do that, without trying to help people develop the skills they need to not run afoul of the order and to understand how to better engage and to change behavior. And for folks who have grown up without the tools to learn those skills, it takes some time. But I've talked to providers who do this program, and they will tell you, I think you heard from one, that most people, when they complete this program, some people get a little bit out of it, some people get a lot out of it. And so having the judge have the ability before there's a criminal involvement, perhaps before, I think it's most likely to come up in those situations. If it's a criminal case too, judge doesn't have to do this. If it's messy and doesn't work, they don't have to impose this. But there are going to be those cases where people want to stay together and the defendant has indicated a willingness to want to learn to change their behavior. And just as Laura said to you, sometimes when a defendant's been saying that over and over again, and then they're given an opportunity to change and they don't change, it's also good information for the survivor about like, how committed are they really to changing? They said they wanted this, they're given the opportunity and they don't engage in it. And then they can make different decisions. So I guess I can tell you the years that I was prosecuting domestic violence cases, every conversation started with the victim telling me, I don't want this case. I don't want to see a crime go forward here. I just want the defendant to get help. And so by adding this, what you do is there'll be a box on the form that the person can check to say that this is the type of relief that they would like from the RFA. And then it's up to the judge. The judge is going to be hearing the exact same evidence. They're already having to listen to evidence to decide whether or not to grant the order. That evidence is the same information that will allow the judge to decide whether the program is important. If the defendant doesn't show up, maybe the judge doesn't have the information to award that relief. That will be entirely up to the judge to decide whether it's appropriate to impose. That may be only a small number of cases. We'll have to see, as I think Charlie offered, that there are going to be people tracking this. There may only be a small number of cases, but it may make a really big difference in those small number of cases. There's a couple of little things I wanted to point out to you. Sorry, go ahead. Did you have a question?
I was late for the table. When the victim comes before the judge, if I understand this properly, usually the victim wants them to seek help anyway. This bill really isn't going to enforce that, right? Because they're already doing that, right? Because I think it's common knowledge that most, unfortunately, a lot of victims, the majority of victims probably go right back to where the initial stuff happened. In an abuse thing, we see it over and over and over again, right? So, and now I've kind of lost my train of thought where I was going with this, but it's like, I like the intent of the bill, adding a tool, but if the person that did the crime, for lack of better words, doesn't follow through with it, what's this bill doing to hold that person accountable?
Well, it's a court order.
But we already have that, right? Without this bill, we already have bills in place for that.
To do programming?
Not programming, no, this is just another tool, but we have laws in place that are already supposed to be holding that person accountable for their actions, for their bad actions, correct?
We do have a lot of laws in place, mostly criminal laws that are designed to hold people accountable. And I think there is some accountability in a court order that the defendant's expected to follow. It's kind of a nudge, you know, like, yes, people could go and get this help if they know they have a problem. They could go and get this help and nobody has to tell them to do it. But the idea that a court says, I think this program could help you and I'm going to order it here is the kind of nudge that some people need to take a step that they weren't taking. And I think it's important for court orders. I don't think you should have different levels of court orders. I don't think you should have a court order that falls under the category of being able to go under 13 VSA 1030 and have a criminal charge filed, and a court order where the judge only has to hold people, only has the option to hold people in contempt. I think as a policy matter, it's not great to have orders with different kinds of relief that can be enforced in only certain ways. But I leave that decision to you all because maybe this is a big thing and it was really hard to negotiate and it just has to be in there. I don't know. But I would think that just having it enforced in the same way that any other violation of an abuse prevention order makes sense. I think one thing I noticed when you all were listening to testimony before is I think there could have been an impression created that somebody's going to be out there like popping up and saying, well, this guy didn't come last week and this didn't do that and filing criminal charge. That's not what happens. I mean, and I think that Kim did a really good job of talking about like they prosecute things that people have brought them a complaint about. They're not out there. Nobody's out there monitoring and policing, at people's moves. Maybe that's a good idea. Maybe it's not. I don't know, but we don't have it in any event. But what we do have is that prosecutors will file charges if somebody makes a complaint and there's probable cause and there's a basis for going forward with it. So if somebody didn't show up to the program because they couldn't figure out how to start their Zoom camera, that's not going to result in a criminal charge. Those folks are going to end up just being told to restart the program. I don't think it's going to result in contempt either, even if contempt is in there. It's just not, we're looking for people who intentionally thumb their nose at the court. Those are the kind of people that you want to be able to hold accountable. And that's what prosecutors' offices are looking for as well. So I don't think it's a shoot that you just end up and then all of a sudden willy-nilly criminal charges result. It's a process where somebody has to make a complaint and then there is the ability for the police to write an affidavit to determine whether there's a basis for it. There's a prosecutor's office that's going to look at it and decide whether to move forward with a criminal charge. So I don't know if I'm answering your point, but I remember you saying several times, we've got a lot of tools in the toolbox. Why do we need this one? And I want to directly address that. It's because this is a tool we don't have. If judges sense that I'm just telling this person not to do this, not to do that, not to do this, but this person is amenable to learning, they just haven't had that opportunity yet. The judge can say, I think this is going to be important. It's a remedial statute. I'm going to require you to go to the program. I think it's going to help you. And we may avoid ever having that defendant in criminal court if we help equip them with the tools to behave differently. The order itself isn't a criminal thing. It's just a civil order against them. It doesn't do anything.
But a judge is already offering that. I mean, those tools already exist in the toolbox. And again, I'm not against this bill. I'm just saying those tools already exist, not explicit to this language, but it's like a judge is going to offer that.
Well, usually the judge just offers what the plaintiff requests. We don't have a lot of judges at relief from abuse orders thinking about like, what else should I impose here? They look at what the plaintiff wants. First of all, that's the starting point. And it's not even on the form that you can request it unless it's a specified form of relief. So even though the statute says that at the final order, the judge can reward any other relief that they think is appropriate, plaintiff is never going to think to request that they're not even going to know this program exists. It's not going to be something they're going to request. And the judge, in my experience, is not likely to just come up with things that they want to put in the order that weren't requested by the plaintiff. So I think you're right. The tool is there. Folks can go to these programs without any kind of court order, but generally they don't. I mean, most of the people that are there because DCF has sent them as a result of like a child situation. There's a little bit of a push. There's some sort of an enforcement mechanism. And I also thought it would be interesting to mention to you all, because I didn't hear it mentioned in the other testimony, that if you take a look at our current criminal VAPO statute, 13 VSA 1030, it says that upon a conviction under, I'm not going to read every word of it, upon a conviction under this section, the court shall, unless the circumstances indicate that it is not appropriate or not available, order the defendant to participate in a domestic abuse counseling or a domestic abuse prevention program approved by the Department of Corrections. The defendant may at any time request the court to approve an alternative program. The defendant shall pay all or part of the costs of the counseling program unless the court finds that the defendant is unable to do so. So I wanted you to be aware of that language, because I do think it sits a little differently than what you have in the
VAPO?
Oh, sorry, violation of abuse prevention order. So when Michelle was going over the language earlier, she explained that there is a provision right now in this that says, first of all, that this program has to be at no cost to the defendant. I will tell you that that is certainly the goal and the intent. Right now, all this program is free, thanks to you all, because you appropriated money because the council came in and said, we don't want cost to be a barrier. It's a barrier for some people. It's not a barrier for everybody. So I think there's some danger, I think, in saying this has to be available at no cost. I mean, if the defendant has the ability to pay, if the program charges, you don't want some defense attorney coming in and saying, Judge, that program isn't offered for free anymore. And, so you can't make my client go. I mean, that's just being a smarty pants defense attorney looking at you. So I wouldn't put that in there, because I think right now it is at no cost. And as long as you feel the state is still able to offer this programming to folks at no cost, it'll always be at no cost, because for people right now that are ordered to go there by the judge, by DCF, it's all free. Sorry, go ahead.
I agree with that. And Karen,
My question is related to that, and I think we're having some folks tomorrow that might be able to follow up, is around capacity for this, to talk about this. And maybe this was covered and I missed it. Do you have a sense, or maybe it's Charlie, of like how many RFAs are done in a year, and to try to understand how many might be looking for this, because there likely will be an expansion in folks seeking programming. And so for us to think budget wise, for providers to think of that, are there any of those numbers available?
There really isn't. I mean, we know that there's about 1,000 final RFAs a year, but that's all kinds of orders. And I think that what's it called? The guardrails around this will be that, generally the practice is, as I said, the court doesn't award things unless somebody requests it. So if this person wants nothing to do with the other person, they're probably just checking boxes of like, I don't want this person to come near me. They're not worried about whether this defendant is going to get help or not. So those folks you could take out. There are also going to be other situations where the judge just thinks this defendant is way too reactive. He's never going to be able to do a program. I'm issuing the order, but this is not somebody that I see going to a program. I mean, there's information out there for judges about every one of these programs. And so I think it's important for judges in their county right now, even right now, when they're just doing the sentencing defendants in criminal cases, to know what programs exist, what are they out there, and what are they like. I think that information is readily available to judges. I think the programs want to make sure that their judges know how their programs operate. So I can't tell you any number, but I think that in the event that this ends up being, a wildly successful and lots of people are going to the program, there will be increased capacity. And when I spoke with Bill Yes, thank you. When I spoke with Bill, he said, I have 2 groups right now, but I'd be happy to open a third if I ended up having more folks. So I'm sorry, Charlie. You want to say- Okay.
Yeah, go ahead and then I'll just speak to it a little bit after.
Yeah, I'm gonna have you back because I have a couple questions for you as well.
Great.
Okay. Sorry, I think, I don't know if I answered that, but
That's,
yeah, that would be great if we ended up having lots of people who want to get help earlier on.
Be better if we didn't have people committing their crimes.
Well, there's always that too.
It would be really nice to see a reduction there, right?
This is a preventative measure. I mean,
It is a preventative measure. That's exactly what it is. And I think it's just important to give judges this option. You know, a lot of times when I talk to judges, they say, I issue this order and I have no idea. I have no idea what happened to these people afterwards. And if a judge wanted to know if they've ordered this program, all the providers I've talked to said, if the judge asked me for a progress report, just because they want to know, like a written piece of paper, I'd send it to them. They do that to probationers. So it's also an opportunity for the defendant to see that the judge cares about them making changes in their behavior and wants to know what happens with them. And for the plaintiff to see that this is a chance for this person to get help before they end up, you know, embroiled in the criminal system. We had it this way for a long time where we only offered people help once they were embroiled in the criminal system. And I won't even get into the reasons why that was probably there. But I think we're in a better and a different place now. And offering this help earlier is going to be, I think, really life-changing for some people.
So I have a question for probably both you and Charlie, actually. So you mentioned you're doing tracking of this. What kind of tracking is going to be done of how this is working?
So the Domestic Violence Council collects data from all of the DVAPs. This looks like, participant numbers, completion rates. I know that they are doing kind of a bigger build out of their data tracking. It started last year. And so moving forward, I think there will be a lot more capacity to examine these programs and completion rates and use a data-driven approach to improve systems around DVAP.
So I mean, the reason I ask is we could put in here request to have this kind of tracking to see how it works. And, I mean, somewhat inclined, I've been trying to do that with bills. But on the other hand, if it's already an entity that's doing this, and it's an entity that will be looking at the data and will be able to say, well, we're not getting as much out of this as we hope. We need to revisit whether we need to have a criminal charge. But it sounds like that's already kind of happening. I mean, I'm just trying to decide if I want to put in something that will help us directly or force us to have oversight, or in this realm, there's the Fatality Review Commission, there's the network, there's the Domestic Violence Council. There's a lot of entities that are keeping track. So I don't know that we need to put that in here. It's kind of, I'm thinking this through as far as whether we actually want it. I also don't want to just have people reporting all the time. I mean, I was inclined to actually, that's why the question for you is whether we should ask the Fatality Review Commission to include in their every other year report to exclude the numbers of people that are going this route. I mean, because we do have that report already.
Yeah, we would be happy to do that. I mean, we already asked the council, I already asked the council whenever they can to provide us with numbers. So if you look in this year's report, it has this many participants went through it. So,
So do
easy.
do we need to have it in law to direct that, or is that something that the Fatality Review Commission would be doing from an informal request that we're making?
I'm happy to do it from an informal request, but I know sometimes people like to have those things in writing. If suddenly I evaporated and, you want to deal with a new person. So I think it would be fine to say that we will report that if it's available to the council. I mean, we get the information from the council that oversees and accredits these programs. So I mean, as long as they have the information available, and as Charlie said, they're planning to build out the data they're tracking and make it even more robust than it is right now. But for instance, for this year's report, I did ask how many people went through programming and things like that. And there's some numbers in there.
So would you be comfortable, Charlie, if the network would be comfortable, or the folks who are gathering this, if we put this into the requirement for the Fatality Review Commission to report this data, the number of individuals who have been referred, then the success rate, essentially, those would be the two.
I think that's something that we would be comfortable with, yeah.
Yeah, Michelle.
Can I just get a clarification? So, so the number of people, defendants who are ordered to participate pursuant to the RFA,
Right.
right? And then the other thing around when you say like successful completion, is that like how, I guess I want to make sure that I'm being clear with the language that it's actually things that you can obtain. So would it, I guess I'm just trying to get a little clarification from that. It would be.
So can you work with
Sure.
the network to, and Carolyn or whoever else to make sure we have that language correct for that? But I think that it would be good to add that. I really do think, since we already get this report, let's direct that gets put in there so we'll know how this is going.
And I think if you tell the council that you want to know how many people are going through this program as a result of an RFA versus going through as a result of a criminal charge, that would be an easy intake question to include that could be
I
tracked.
think that's easy. I think maybe the outcome of that referral, that's what I'm not clear about what information you could obtain.
No, that's,
and get.
I see what you're saying. They know how many people complete their program, because when they complete, they're done and they're not in the program anymore. So they're tracking how many people show up and how many people finish the program.
So what is doable for you as the commission would be to identify the number of people who are referred through the RFA process and who subsequently complete the process.
Yes,
And I could say that, and that's doable for you. I
absolutely.
just want to make sure I'm
Excellent. No,
not
that's fine.
creating
That's great. Yeah.
something to keep doing.
No, that's great. That's great. Other questions though? That was my big questions. Tracking. I think we're good. Just as far as, I'm very much inclined to keep the language as it is, and especially if we're going to be tracking this, and that's kind of my sense of the various questions and where various members of the committee are, that this is a different animal than all the other types of orders. It seemed a little. I mean, it is a different kind of thing. So I think people are more comfortable with not having it under 13 VSA 1030 at this point, but it can be revisited. We'll see how this goes, and that's part of the reason for getting this tracking data to see how it's going. So if this is sufficient to get this working, then we'll go with it. But if it looks like we're not getting as much of a take for it, then we can revisit that component. But I do also just, Michelle, I would strike the at no cost to the defendant. That I hadn't really thought deeply about, but that really concerns me of whether what if the money goes away? And so I agree with Carolyn that we should strike that. Yeah.
I don't want to throw a huge wrench here.
Well, sure. Wrenches.
So I've been sitting with this language for like a week and a half, I guess. I would be willing and interested in considering striking the civil and moving it back into a criminal charge. My feeling on it is that feels kind of clunky. And I don't know why we would be sort of saying that this is less important by having it be a lesser consequence for non-compliance.
I'm talking to Angela.
No, I've talked with a lot. I think the other thing is that I'm feeling better about the confidentiality element and that there's capacity. And those are the things that were very concerning to me. So I know that's kind of a wrench, but
Well, it's a wrench if we go that way, but I think that, I'd like to understand, where other members of the committee are. Personally, I prefer this approach.
okay.
At this point, if I was reading Tom Oliver, who is online right now, if I was reading his questions right, he might be more comfortable with this approach. Tom, do you hear me?
I am much more comfortable with your approach.
Yeah, so I read you correctly. So I think let's see how this goes. I mean, it can be revisited, but this gets it started, which I think is a key part. It would be kind of where I think this.
Well, thank you very much for your time, and I'm always available if you have questions. We support the whole bill, by the way. I just decided because fatality review, that was our piece to focus on that, but we do support.
So while I have you with us, just as a heads up, so we have another bill, H221, which deals with having a task force looking at compliance for relinquishments of firearms. I actually hadn't planned on taking that up, but I understand that the Senate might be looking at a pared down version of what we have in 221 for the miscellaneous bill. I personally don't think it's necessarily appropriate for the miscellaneous bill. It depends on where the rest of this committee is, because for miscellaneous bill, we generally, our tradition is that only things that are unanimous go into that bill. At least that's been the tradition. So I have the pared down language, and I'm going to send it on to Michelle. And I am going to try to fit that in the next couple of days to take a look at it.
Thank you.
So, and for members of the committee, it may be a later day tomorrow, in part because of that, and in part because we have two other bills that we're still trying to get out. So folks should kind of plan that we're going to come back after the floor tomorrow, and that may even be a little bit later than usual. But I am going to kind of try to get started at least with the walkthrough of this proposed tightened language. If Michelle's going to be available tomorrow morning, we'll see. We'll see her calendar. I just set it to date maybe a little bit before, and we'll probably just have one or two witnesses if we can fit them in tomorrow, or tomorrow morning, and then have the rest after the floor. Which also may mean a late night for witnesses, but we'll take people by Zoom if they need to come in by Zoom. So we'll get that language drafted and get it out to folks
Whatever you need from me, I'm happy to do.
So we'll take a shot at that. I shouldn't say shot at that since it involves fire. I apologize. I have to owe $1 to one jar. So